could probably wear that to the very end.
I don't know
You're so
about
tiny
that.
and cute.
No, probably not quite.
It's a lot of fun being at the same stage, and I think each one of us carries differently, and so there's going to be stuff that works for one of the sisters that's not going to work for another, so it's just kind of seeing what works for everybody. I'm definitely one of those that if someone else is crying, it doesn't take long, and usually I'm crying too. Especially if it's someone that I love, like if it's any one of my family members, and if it's any good friends of mine.
There is a moment in every legal case where someone overplays their hand, where they say something in front of a judge that they probably should have thought twice about. For Joseph Duggar, that moment may have come early, and it may end up mattering more than anyone expected. Everything discussed here comes from public court records, verified news reporting, and official legal documents. Most people know the Duggar name from TLC. The family built an entire brand around one idea: wholesome, faithful, above reproach. 19 Kids and Counting ran for years. It made them genuinely famous. And for a long time, that image held together remarkably well. But if you have followed this family closely over the past decade, you know the cracks have been showing for a while. Josh Duggar's federal conviction in 2021 was the most devastating blow to that image. And now a separate legal situation involving his younger brother Joseph is raising its own uncomfortable questions. Here is the specific question this video is going to answer. When Joseph Duggar's attorney stood before a judge and described his client as someone with zero criminal history, not even a traffic ticket, was that actually true? And if it was not true, what does that mean for his bond situation going forward? Let's set the scene. At Joseph's first court appearance in Bay County, Florida, his defense attorney made a straightforward argument to the presiding judge. The argument was essentially this: my client is not a flight risk. He has no criminal record. He has no history of failing to appear. He is a law-abiding man, and you can trust him to return to court. That kind of argument is standard practice in bond hearings. Defense attorneys make it every day. The goal is simple: convince the judge their client deserves release and at a manageable bond amount. The problem is that argument only works if it is accurate. A review of Joseph Duggar's driving record in Arkansas tells a different story. According to court records obtained directly from the clerk of the court, Joseph had accumulated at least 4 traffic citations. That alone contradicts what his attorney told the judge. But the traffic tickets are actually not the most significant part of this. On November 8th, 2020, Joseph was cited for improper driving on North Benton Road and Arlington Way, not far from the family property. According to the citation, he was traveling 58 miles per hour in a 35 mile per hour zone. That is more than 20 miles over the posted limit. There was a minor in the vehicle at the time. He was issued a court date. The fine to resolve it was $25. He did not show up. On November 25th, 2020, Joseph was required to either pay his fine or appear before a judge. He did neither. 6 days later, on December 1st, 2020, a warrant was issued for his arrest. The charge escalated from a simple traffic citation to a Class C misdemeanor failure to appear. His driver's license was suspended the same day the warrant issued. This is the part that most people overlook. A Class C misdemeanor is a criminal conviction. It is not a parking ticket. It is not a warning. When Joseph eventually resolved this matter, paying $585 instead of the original $25 and entering a no contest plea, the court entered a finding of guilt. That finding sits on his record. So when his attorney stood in front of a Florida judge and stated that Joseph Duggar had never had so much as a traffic ticket, that was not accurate. And when that attorney used that characterization to argue Joseph was not a flight risk and had no history of failing to appear, both of those claims had a direct factual problem sitting in Arkansas court records. Florida law is specific about what judges must consider when setting bond. The statute lists the defendant's past conduct, any record of prior convictions, and notably any prior failure to appear at required court proceedings. A prior failure to appear is not a minor footnote under Florida law. It is a listed factor the court is required to weigh. And in certain circumstances, it limits the types of bond a defendant is even eligible to receive. Jim Bob Duggar paid a $60,000 non-refundable premium to a Florida bonding company called A1 Bonding to secure his son's release. That premium is gone regardless of outcome. If Joseph were to fail to appear again, the full $600,000 bond amount could be demanded from the Duggar family immediately. What makes this worth noting is the pattern. The family that built its public identity around accountability and honesty apparently had no problem allowing inaccurate information to be presented to the court at a critical moment. Whether that was the attorney's oversight or something more deliberate, the effect was the same. A judge made a bond decision based on a picture of Joseph Duggar that the actual court record does not support. If the prosecution in Bay County is paying attention, they now have grounds to push back. Florida courts take misrepresentation in bond proceedings seriously. There are mechanisms to revisit bond conditions when new information surfaces or when information that should have been disclosed the first time finally comes to light. Here is what this case keeps coming back to. The Duggar brand has always been built on the idea that this family operates differently, more transparently, more faithfully, more honestly than the average family. But at every point where that image has been tested against documented reality, the documents have told a different story. A $25 traffic fine turned into a criminal conviction because Joseph Duggar did not show up when he was supposed to. Years later, that same pattern, not showing up, not being forthcoming, appears to have followed him into a Florida courtroom. Whether there are legal consequences for that this time around remains to be seen, but the record exists. It is public. And it is not going away. There is a moment in every legal case where a defendant's own actions become the prosecution's best evidence. Joseph Duggar may have just handed prosecutors one of those moments, and the strange part is it happened inside a routine court filing. Everything discussed here comes from public court records, verified news reporting, and official legal documents. Most people know the Duggar name from the long-running reality television series 19 Kids and Counting, which aired on TLC for years and built the family into a household name. Josh Duggar, the eldest son, was convicted in 2021 on federal child sexual abuse material charges and is currently serving a 12-year federal prison sentence. That conviction reshaped how the public views the entire family. But this story is not about Josh. This story is about his younger brother, Joseph Duggar, and a legal situation that has been escalating quietly in Florida courts for months. Joseph Duggar is currently facing a serious felony charge in the state of Florida. The specific charge carries potential life imprisonment. He has been released on bond while the case moves forward, and like most defendants in that position, he was given a set of release conditions to follow. Those conditions were not complicated. Stay away from locations connected to the person impacted by the case. Do not make contact. Keep a minimum distance of 500 feet. These are standard protective measures in cases involving allegations of this nature, and courts take violations seriously. What happened next is where this story takes a turn that is hard to explain away. On May 18th, 2026, Joseph Duggar's legal team filed 2 separate motions with the court. The first asked for modification of his no-contact conditions so he could spend time with his children. The second asked for modification related to properties he owns. On the surface, these filings are not unusual. Defendants seek bond modifications regularly. But buried inside that second motion was something that should never have appeared on a public court docket. The state of Florida has a statute known as Marsy's Law. Under this law, any information that could publicly identify the location or identity of a person impacted by a crime is classified as strictly confidential. That protection covers current addresses. It also covers former addresses. The reasoning is straightforward. Even an old address can be used to track someone. The motion filed by Joseph Duggar's defense team included an address. According to the state's subsequent filing, that address was connected to the family of the person impacted in this case. It was placed on a fully public court docket without the required confidentiality protections, in apparent violation of Marcy's law. The state moved quickly. Prosecutor J.P. Farrer filed a formal notice of confidential information within a court filing citing Florida Rule of Judicial Administration 2.420-D2. That filing identified the precise location of the confidential information within the defense motion and formally notified the clerk of the court that the document required immediate review. Here is where the timeline gets more complicated, and this is the part that most coverage has not focused on clearly enough. Inside the same motion where the address appeared, Joseph Duggar's legal team made a factual claim to the court. They stated that the property in question had been abandoned, that the people connected to the case had packed up and moved out. Think about what that claim requires. In order to represent to a court that a property is vacant, someone has to know it is vacant. Someone had to verify that. Under the terms of Joseph Duggar's existing no-contact order, no one connected to him, not his associates, not family members acting on his behalf, is permitted to go within 500 feet of locations connected to the protected party. That prohibition exists precisely to prevent any form of monitoring, surveillance, or intimidation. If someone physically verified that property was empty, that act itself may constitute a bond violation. The defense motion does not explain how this information was obtained. It simply asserts the property was abandoned as a stated fact. That gap is what prosecutors now have in front of them. The consequences being discussed publicly range significantly. At the lower end, the address gets sealed, the motion gets denied, and the filing is treated as a procedural error. At the higher end, Joseph Duggar's attorney could face sanctions or a report to the Florida State Bar for exposing confidential victim information. And if prosecutors pursue the question of how the defense obtained knowledge about the property's status, the bond violation issue comes directly into view. Bond revocation in cases like this is rare, but it is not off the table, particularly when a defendant facing a life felony charge appears to have knowledge he should not legally possess. What makes this situation worth paying attention to is the pattern it suggests. This is not a single misstep. The record in this case already includes a failure to appear and prior traffic violations. And now a court filing that simultaneously seeks a modification of protective conditions while apparently exposing the protected party's former address, the same address the motion claims is no longer occupied. That is a contradiction that prosecutors did not create. The defense created it themselves. The clerk of the court now has a defined window under Florida procedural rules to determine whether the information meets the standard for confidentiality protection. If the clerk confirms it does, the document gets sealed. If the defense contests that determination, it escalates. Either way, the state has a documented record of this filing that will not disappear from the case file. A federal jury found Josh Duggar guilty in 2021. What a Florida jury ultimately finds in the case of Joseph Duggar is still an open question. But what is not an open question is this. When you are facing a life felony and released on bond, the absolute last thing you want is to hand the prosecution a new set of questions about whether your conditions were followed. And yet, that is precisely what this filing appears to have done. Whether this was a careless oversight by a defense team operating under pressure or something more deliberate is something the court will evaluate. What is clear from the public record is that a document meant to expand Joseph Duggar's freedom may have instead tightened the walls around him. That is worth watching closely.